video covers the subject of laying the foundation for an exhibit. Foundation is the responsibility of the proponent of an exhibit. And fundamentally, it's what provides the basis for a court to decide, in the first instance, that an exhibit is sufficiently worthy to be considered in deciding a case, either by the court or by a jury. Every exhibit has to be ruled on. That is, it has to be admitted in evidence by the court. So laying foundation is very basic to the lawyer's task. We'll talk about how to lay the foundation for a document. There are lots of other kinds of exhibits. There are photographs, there's medical images, there are videos, audios. There are sometimes objects and substances, there are models, you can also have animations, simulations, demonstrations, and reconstructions. And the foundation for all of those, while it follows the same basic formula, involves some different steps. So we're going to concentrate here on documents. So when you're dealing with a document, fundamentally a piece of paper with words on it, you're necessarily dealing with hearsay. But hearsay objections, just like objections claiming the lack of an original document or undue prejudice and confusion and delay, those kinds of objections are not objections to foundation. How the proponent of an exhibit deals with these types of objections is covered in another video in this series. So this video covers laying a foundation for documentary exhibits and how the proponent of the exhibit defends against objections to foundation. So let's start with the basic proposition that if a deposition is taken in the case, that is the time to qualify exhibits. Rule 104 of the federal rules allows the court to consider affidavits and deposition testimony in deciding whether an exhibit is admissible, even though those are out-of-court statements and technically they are hearsay. If you get the testimony during a deposition that makes the exhibit admissible, then you don't have to take any time at trial or face any risk of doing it at trial. In fact, most judges insist that exhibits either be agreed on or objected to and dealt with pre-trial. However, we're going to assume here that we're qualifying a document at trial. So if you're at trial, and particularly if you're in front of a jury, you really want this to go smoothly. And going smoothly in the first instance means you followed the traditional courtroom, what we call dance steps in using the exhibit. Here they are. The first one is mark. The exhibit's been marked with a number, and that almost always occurs at some point in the pretrial process. But if you come across something that for some reason hasn't been numbered, before you do anything else with the exhibit, you would say, let the record reflect that I am marking this document as Exhibit 12, or whatever number comes next in the exhibit series. In some courts, marking is done by clerks, in which case you'd say it that way. After mark comes place. Before you start taking any testimony about an exhibit, you need to place it before the witness, before opposing counsel, and before the court. This is usually done by reference to an exhibit book that has been agreed by counsel ahead of time and that is already on the witness stand before the court and sitting in front of opposing counsel. However, if that's not the case, you need to say, let the record reflect that I am handing what has been marked as Exhibit 12 to counsel for the defendant or whomever the opposing lawyer represents. If you have to hand the exhibit to the witness or to the court, you first need to ask permission. So you would say to the court, may I approach the witness? So after marking and placing, now you come to laying the foundation. Now you turn to the witness and you get the testimony that provides the foundation for the exhibit. We're going to talk in detail about each of the four legs of foundation in a minute. They are the competence of the witness, identification of the exhibit, the relevance of the exhibit to a fact at issue of the case, and the authentication of the exhibit. When you get done laying the foundation, you offer the exhibit in evidence. As soon as you're finished with foundation testimony, you offer the exhibit. This calls upon your opponent to object to some element of the foundation, and it calls on the court to rule. After you lay the foundation and offer the exhibit is the time for meeting objections, if there are any. There are two sets of potential objections to an exhibit. First, there's objection to foundation, and second, there are objection on grounds other than foundation. You need to meet any objection to either one of these with an explanation as to why either the testimony already on the record is sufficient, or you may need to go back to the witness to get whatever additional testimony is needed. And after meeting the objection, then you need to offer the exhibit again. And the last step is publish. Of course, the whole reason for using exhibits is to get them before the judge or jury so they can be used as a basis for deciding some issue in the case. Normally, in a jury trial, you'll want to publish every exhibit in some acceptable way. Traditionally, this was done by passing the exhibit to the jurors or giving each juror a copy to put in the juror notebooks. Now, more commonly, the exhibit is displayed on a big screen in the courtroom. So, 6 steps in using every exhibit: mark, place, lay foundation, offer, meet objections, and publish. So, now we're ready to go about meeting the basic requirement that every exhibit have a foundation. Under the federal rules, there are 4 legs supporting a foundation. This is one of the parts of a trial lawyer's skills that depend on memorization. And that, in turn, is usually best done with some device that helps you bring those memory items out quickly and efficiently. Lawyers have quite a few personal methods for doing this. We're going to use one that's easy for lawyers with less trial experience. So, for quick reference, we can call the 4 legs supporting foundation as the C, I, R, A factors. C is for competence. The witness who sponsors the exhibit has to be competent. I is for identification. The witness has to supply an identification of the exhibit so the record can be clear as to what the exhibit purports to be. R is for relevance. The exhibit has to be relevant to an issue in the case. And A is for authentication. The exhibit has to be authenticated sufficiently. That is, we have to know that it actually is what it purports to be. So now let's look at these 4 criteria to see how they're usually established from witness testimony. So let's start with competence. The rules require that a lay witness have first-hand knowledge of the subject about which the witness is testifying. Normally, the witness's first-hand knowledge will be evident for the reason that the witness has for recognizing the exhibit. Second is identification. The lawyer needs to first mark every exhibit with a number so it can't be mistaken for anything else in the record. And then the lawyer establishes the necessary identification by asking the witness, "What is Exhibit 2?" And the witness explains, "It's a letter he wrote," or whatever the exhibit is. The witness just needs to tell us what the exhibit purports to be. And then, almost every reference to the exhibit in a lawyer's question should refer to it by its number, so you're making a clear record. Third, we have relevance, and in many cases the relevance of a document is apparent from its face, so nothing further is needed from the witness about this. But if not, ask questions of the witness to show the connection. It's important to include relevance on your checklist and be able to explain it if you're challenged. One easy way to do this is to ask yourself for each exhibit that you're planning to show to the jury, why am I putting this exhibit before the jury? If you don't have a good answer to that question, maybe you should scratch it from your list. If you do have a good answer, that's what you tell the judge if an objection to relevance is made. And lastly, a little bit more complicated, we have authentication. Here we're faced with what is it that makes it sufficiently clear that this is the real thing, the authentic thing, so that a judge should allow a jury to consider it in arriving at a decision on the issues in the case. This is usually accomplished by asking the witness, "How do you know that?" after the witness explains what the document is. Unfortunately, there's no one rule on foundation for exhibits in the federal rules, and that is also the case with most state rules. Here are the references to the federal rules. All state rules have comparable provisions. The competence of a lay witness is governed by Rule 602. That provides that a lay witness may testify to a matter only if evidence is introduced to support a finding that the witness has personal knowledge of the matter. Rule 701 allows lay witnesses to testify to an opinion in certain quite limited circumstances. The competence of an expert witness who can testify to an opinion is a separate subject covered in another video. The identification of an exhibit is governed by Rule 901A. That simply requires the proponent of an exhibit to state what the exhibit purports to be. The relevance of an exhibit is governed by Rule 401, which defines it this way. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Now, that's a mouthful, but the operative part is any tendency. So you link the exhibit to a fact that's of consequence in the action, and it meets the relevance test. Now for authentication. This is a little bit more complicated. Rule 901A defines it as evidence sufficient to support a finding that the item is what the proponent claims it is. So let's step into a courtroom and see how this goes. We'll assume Dr. Love has already testified about his personal background and his practice, and now Dr. Love's counsel is laying the foundation for Exhibit 2, which is the letter from Dr. Love to Dr. Segan, and Exhibit 5, which is the letter from Dr. Segan back to Dr. Love. Dr. Love, what did you do once you found out about Regency's ad campaign in your town?
I wrote the head of Regency a letter.
And when did you do this?
In September.
What was your purpose in writing the letter?
I wanted them to stop what they were doing.
Would you turn in the book of exhibits that's at the witness stand to what's been marked as Exhibit 2, please?
Yes.
What is Exhibit 2?
That's the letter that I sent to Regency.
What is the date of your letter?
September 13th.
Whose signature appears on the letter?
That's my signature.
Dr. Love, would you now turn to what's been marked as Exhibit 5, please?
Yes.
What is Exhibit 5?
That's the letter that came in the mail addressed to me.
What is the date of Exhibit 5?
October 6th.
Whose letterhead appears at the top of Exhibit 5?
Regency Plastic Surgery, PC.
Is that letter signed?
Yes, it is.
What is typed below the signature?
Diana Segan, MD.
And how does this Exhibit 5 relate to your letter that is Exhibit 2?
Well, it's the answer to my letter.
And how do you know that?
Because the letter is addressed to me, it refers to my letter, and then below the type is the signature to whom I sent the letter.
Your Honor, we offer Exhibit 2 and Exhibit 5 in evidence.
Objection to Exhibit 2. It contains Dr. Love's lay opinion on the law. that is not within the limited scope for lay opinions under the rules.
Your Honor, Exhibit 2 contains only a statement of Dr. Love's state of mind, not any opinion.
We maintain the objection to Exhibit 2 and ask that the statement be redacted. In addition, there's another objection. There's no foundation for Exhibit 5.
Your Honor, we've established the foundation for this exhibit. First, Dr. Love is testifying from his first-hand knowledge. He wrote Exhibit 2 and he received Exhibit 5. Second, we've identified Exhibit 5 with particularity. Third, Exhibit 5 is relevant to the issue of Regency's use of their slogan despite Dr. Love's written objection. And fourth, Exhibit 5 has been authenticated under Rule 901b4 by the circumstances of its content. It was addressed to Dr. Love. It mentions his outgoing letter, which shows that Exhibit 2 was received by Regency, and it was sent by the person to whom Dr. Love addressed his letter. So we've produced evidence sufficient to support a finding that Exhibit 5 is what we claim it is, which is Regency's answer to Dr. Love's letter of September 13. With that defense of the foundation, a court likely would admit Exhibit 2. It's possible that a court would require redaction of the phrase in Dr. Love's letter that says, "and constitutes an unfair and unethical business practice." That might be done. And the court is likely to also admit Exhibit 5 if there were no additional objections on grounds other than foundation. In the case of either of these exhibits, there may be objections on grounds other than foundation. For example, Exhibit 5 is hearsay. It's an out-of-court statement by Dr. Segan. That would not be an objection to foundation. That's part of what I like to call the HOPS objections, HOPS, which stands for hearsay, original document, fairness policy, and surprise. There's a separate video in this series on how the proponent of an exhibit deals with objections of this kind that are not directed at the foundation for the exhibit. And just a quick note on the form of the question when you're laying foundation. Foundation is a preliminary question. So although you know that Rule 611C forbids leading questions on direct examination in most cases, Rule 104 specifically provides that in dealing with a preliminary question, a court is not bound by the rules of evidence. So you can use leading questions in laying a foundation, and you can use them in defending against an objection. But for the most part, it's really a good idea to keep in a non-leading mode on all direct examination, including dealing with exhibits. You really should restrict your use of leading questions to circumstances when you really need to fit within the specific wording of a rule. And on those occasions, just put the words of the rule in your question to the witness. Now, let's look a little more at the requirement for authentication of documents, because that differs depending on the kind of document you're trying to get admitted. Under the federal rules, there are basically 3 roads to authentication for an exhibit. The first, and most common of course, is the first-hand knowledge of a witness, usually about the origin or creation of the exhibit itself. Rule 901b1 provides for testimony of a witness with knowledge that an item is what it is claimed to be. The rule provides that specifically meets the authentication requirements. Some kinds of exhibits derive their authentication from the same testimony from the witness that establishes identification and relevance. Now, second, an exhibit can be qualified by circumstantial evidence under Rule 901b4, which covers what's called distinctive characteristics, or also by other kinds of circumstantial evidence under Rule 901b, 7, 8, 9, or 10. In these cases, the witness needs first-hand knowledge of the qualifying circumstances, but not as to the origin or creation of the document itself. These rules are very broad, and they provide authentication for many kinds of documents. Third, and more limiting, the document may be self-authenticating under Rule 902. This covers 12 categories of documents that are published documents in general circulation. This is like newspapers, periodicals, government publications, those kinds of things. This rule also covers certified or notarized documents, usually some kind of certified government record or notarized private document like an affidavit. In these cases, the witness usually doesn't need to do anything on authentication. The testimony on identification and relevance will suffice here. So there's some secrets of success with respect to your plan for authentication of your documents. And I guess it goes without saying that you need a plan. There should be no surprises with respect to authentication. You know what exhibits you're going to use, so make sure you can authenticate each of them. Secret to success number 1, first-hand knowledge comes first. Of the 3 roads to authentication, first-hand knowledge of a witness about the document itself is the easiest and safest. So, if possible, you would always go there. Secret number 2, circumstantial evidence can go a long way. Use Rule 901b4 to build authenticity when the witness does not have the necessary first-hand knowledge. You can see this with Exhibit 5. That's the letter from Regency, but Dr. Love, who's the witness on the stand, doesn't know anything about its origin or authorship or signature. However, he has first-hand knowledge that he received it, and he can testify as to quite a few circumstances that qualify it as the answer to his letter. That's the letterhead, the date, the reference to his letter, and the typed signature line. Secret number 3, habit and routine may be helpful. Rule 406 allows evidence of a person's or an organization's routine practice to be admitted to prove that a person or organization did, in fact, act in that way on an occasion in question, even though the witness has no personal knowledge that that happened. The rule specifically provides that this evidence can be admitted even without corroboration or any eyewitness. So, in the case of Exhibit 2, for example, in order to make Dr. Love's letter relevant, you have to establish that it went to Regency. If Dr. Love did not personally mail his letter, he could testify to the habit and routine of his office that letters given to his office assistant for mailing were stamped and mailed the same day. Secret number 4, if you have a numbers document, that's a computer printout, a table, a chart, a spreadsheet, something with a lot of numbers on it, Rule 901b9 is invaluable. That rule allows you to put in evidence a description of a process or system and a showing that it produces an accurate result. So in the case of Dr. Love's Exhibit 3, that's the chart of his revenues and expenses, that work was done by his bookkeeper, not him. He doesn't have any personal first-hand knowledge of that work. So he can't testify directly as to the accuracy of the numbers. However, he can describe the process of using the software that created the table, and he can testify to his personal knowledge about its accuracy when it is used in his business. Number 5, and something always to keep in mind, You can always use an affidavit to fill in parts of a foundation if you can't get them from a particular witness. If a witness can't lay the entire foundation, under Rule 104, you can use an affidavit from another person who does have the requisite personal knowledge and complete the foundation that way. Now remember, we've been talking about authentication. Authentication gets you a foundation. It does not get you by the hearsay rule. There's some similarities between the bases for authentication and the exceptions to the hearsay rule. But you should keep the two separate. You should keep them separate in your head, and you should keep them separate in your presentation. Lay the foundation first. That lets you offer the document in evidence. Then turn to defending against objections on grounds other than foundation. You always need a foundation, but you need to defend against objections on grounds other than foundation only if the objection is actually made in a timely way. Your opponent may miss the objection altogether. So when your adversary says, "Objection, no foundation," you say, "We have established the foundation under the requirements of the rules. The witness is competent, the exhibit's been identified, the exhibit is relevant, and we have provided sufficient authentication that the exhibit is what it purports to be." That forces your opponent either to be specific about the element of foundation that's questioned or to state some other objection. If there is some other objection, then you can move to your defense with respect to that objection. And you won't be sliding around trying to do too many things at once. Dealing with these objections on grounds other than foundation might require you to go back to the witness and elicit more testimony. We have another video on these methods, but you can turn to this task calmly, and when you finish, then you just offer the exhibit again. So, that completes our presentation on the basics of laying foundation for exhibits that are documents and for meeting objections to the foundation for these documents. Documents are usually the large majority of exhibits in a trial, and these methods should allow you to make the most of the evidence you've got that supports foundation.